We are now going to call to order the September 9th, 2021 meeting of the Abington Township Board of Commissioners Committee of the Whole. Our first agenda item, actually, I have an announcement to make and then a statement from Commissioner Carswell. The first announcement is, as you know, earlier this summer, the Township Manager and I have been charged with taking a look at the public participation aspects of how we've been doing our business over the last year, the Committee of the Whole. And so we started down that path, and it evolved into a much more thorough review of how the board does its business in general. The manager and I have been looking at the functioning of the Committee of the Whole, examining the committees that we've had, and trying to come up with a thorough and comprehensive proposal for the board to consider about how we will conduct our business into the future. We are putting the finishing touches on this, and we'll be ready for a thorough public discussion on this matter at the October meeting. And between now and then, I will be reaching out to you individually to give you a preview of what it is that we're contemplating, to answer questions so that we can have a substantive dialogue and ultimately get to a place where we're comfortable that we are conducting our business that is engaged around our highest priorities while maximizing the opportunity for public participation in the process. Manager Manfredi, would you like to comment?
Well said, Commissioner. The only thing I want to make sure everyone understands is we did not lose sight of the comments made by commissioners as it relates specifically to when public comment is taken and how long public comment is to be had. That will be a part of this.
Well said, thank you. And now I'll briefly turn to Commissioner Carswell, who's going to make a statement about one of the items that is on the agenda.
Thank you. I have spoken with a number of fellow commissioners, and I've consulted with the township manager about the policy that we discussed 2 months ago when I was remote, dialing in by phone. So my sympathies to everybody who's balancing that tonight. We were looking at the policy for how we handle the appointments, the interview, selection, and appointment process for our various volunteer boards. Anything from the EAC to the Economic Development Committee and so forth. Based on those conversations still being, still hashing out some pieces, and what you just said yourself about looking at our committee structure as a whole, I'd like to make a motion to move this from tonight's agenda so that we can come back to it in a little bit more detail with a better fleshed out policy.
So Commissioner Carswell has made a motion. And
Second.
Okay. So it's been moved and seconded, and the motion is to move this agenda item off of the meetings this evening. Any comments or questions before we vote? Does anyone on Zoom, any commissioners on Zoom have any comments or questions? Okay, thank you. Hearing none, all those in favor?
Aye.
Aye.
Any opposed? Okay, hearing none, we will move that item from this evening's agenda. So the first order of business is a motion to approve the minutes from the Board of Commissioners Committee of the Whole meeting of July 8, 2021, and I so move.
Second.
It's been moved and seconded. Any comments or questions about the minutes? Hearing none, all those in favor?
Aye.
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 Any opposed? Minutes are approved. We will now turn to public comment on agenda items only, and we will see if anyone present who wishes to comment on this evening's agenda. Thank you, Mr. Rooney. Are there any comments from members of the public who are attending via Zoom? We see we have one. If you could let her in, please.
This is Laura Lehman. Okay, and it looks like Terry's got the microphone off. Thank you. I appreciate that. Basically, I just want to say, you just discussed as on the agenda, the issue of the speaking rights, and you have no place in there for the public to help you decide what these rights should be. You took away 12 minutes each month of our speaking rights. So when you violated the Sunshine Law, there was no place to address it. We had open comments with each of the committee chairs for 3 minutes before. And when you created the committee of the whole, you jumped over them and took them away. And so there is no place, and in this meeting right here, you should be having open comment at the end of the meeting to address any of the committee chairs so as to replace that. Please do not have a public policy that does not involve the public. They're the ones that will tell you what they need to be able to help you understand what's going on with us that we need you to address. Okay, so the issue of the public speaking is highly, highly important. The naming rights that are coming up, I see you're removing the number of years. I'm pretty sure that was 5 years when we first proposed it. I don't know how it got down to 3 years, but it was 5 years after somebody left that something could be named after them. And I told the story when we were deciding that naming policy originally, that there was a commissioner who would not help the residents get a community center. And so the residents came up with the clever idea of, what if we tell him we'll name it after him? Then he'll help us get the money for it. That's what's wrong with this policy. There is nobody who uses township money to do their good deeds that actually should be getting things named after them. There's plenty of individuals that rise to that. So we have lots of names we can come up with, but not like that. The other thing that I wanted to talk about here is the medical patio. I don't see the EAC or any of the environmental organizations that we spend so much time and money promoting. And here we are in a township where flooding right at that corner where that medical patio is going to go, or that, not medical patio, I'm sorry, it's the medical center at Rydell Park. And right at that corner where you have had people in that room yelling at you at the top of their lungs to do something about the flooding there. Then you approve 244 units on a steep slope right behind that. Okay, that's going to help. And now you have a medical patio, I keep saying that, a medical building with a patio that is in the buffer zone. You do understand that when a creek rises, it needs a zone for the water to soak in on the banks of the river. Okay, and when it doesn't soak in there, that means it's going to go somewhere else, to somebody else's property, to those very people who were there yelling at you before. So please don't do that. Please, let's get this straightened up so that we do have something. And also, as far as procedures go, per the Sunshine Law, I have the right at any meeting to interrupt and tell you if I have a perceived violation of the speaking rules, which we had again and again. And not only that violation, but also, Commissioner Hecker, the evidence from both the solicitor's office and from yourself of violating that law were erased from our tapes. That's not okay. You have absolutely, we are not allowed. It's gavel to gavel is how our minutes are to be. And by doing that, it was a clear effort to remove the evidence of you breaking the law. So please put those back, number one. And number two, we need somewhere, I would like you to call me. You're my commissioner. Everybody just saw how responsive a commissioner you are. But I would like you to call me and tell me what we're going to do about those kinds of things, about violations of the law that are serious. You're not allowed to do that. So please, Commissioner Hecker, I would like to hear from you, okay?
Thank you for your comments, Ms. Lehman.
Is that right?
We have one other member of the audience.
Miss Evans, your microphone. Oh,
Good evening. This is Khaki Evans from 1132 Lindsay Lane. Our EAC and Shade Tree Commission, we do have comments about the Rydell Park proposal. Maybe I couldn't hear Ms. Lehman, but it appears on page 99 of the agenda packet, if there's any confusion. We did weigh in on it. We do have recommendations, and we certainly ask that if this is approved, that you hold the Rydell Park very accountable in monitoring it. It's not optimal, but we do have some recommendations, and thank you.
Thank you, Ms. Evans. Seeing that there is no further public comment on the agenda items, we will move to matters of unfinished business. Item A is for us to consider a resolution amending the policy regarding the naming of township facilities, and for this I will turn to Township Manager Mr. Manfredi.
Thank you, Vice President Hecker. As you know, in 2017, a policy was created for the naming of township facilities. That resolution is in the meeting binder. In 2020, there was a proposal to simply strike the 3-year requirement, as there was an individual who was requested by a commissioner, made the request of me to name that facility, but that individual had left the township prior to the 3 years. At least 2 other commissioners have spoken to me about making sure that someone that had worked for this township for more than 40 years was recognized. And the reason for the timing of this being on this month's agenda is that gentleman, Mr. Edmund Michelow, worked so hard on we'll call it at War Memorial Island, on a memorial park. And the idea was for this restriction to be lifted so it could be named before Veterans Day, which would require consideration this evening and a vote next month. And I believe Commissioner Myers, Commissioner Spiegelman had made this request as well. So what's in front of you isn't necessarily a request to strike that language and amend this. I would defer to the solicitors to whether or not the board can simply make an exception to that provision or relax that provision if you choose to keep the 3 years. I know there are other members of the board who have come to me to initiate the process for other individuals who had served. In one case, the 3 years is now passed.
Yeah.
And in 1 or 2 other cases, the 3 years has not. But this evening is specific to one gentleman, Edmund R. Michelow, and the request is to name at War Memorial Island, Edmund R. Michelow Park at War Memorial Island.
Yeah.
I think one of the questions that came up last time is there was a misunderstanding that the island itself, War Memorial Island, was being renamed. And that's not the case. It's a recognition of the memorial that was built in the park at War Memorial Island. And that was the request that was made of me. And of course, because of this provision, I cannot process the request.
Understood. Thank you, Manager Manfredi. Before I open it up to a conversation among commissioners, I'm going to ask our solicitor to weigh in. I mean, the language there does say, as a general guideline. So if you could give us your legal interpretation of general guideline.
Sure. So this is, first of all, a purely discretionary policy that the Board of Commissioners has passed. The board can amend it as they see fit, or the board can, in a particular circumstance, can choose to waive a particular provision without waiving it generally. But as you're saying, the language in here indicates that it's more of a guideline than a hard and fast rule. So if the Township Board of Commissioners chose to deviate from that guideline for this one particular matter or piece of property, it's well within your discretion to do so.
Okay. Thank you, Solicitor Clark. I'll now open it up for comments and questions from my colleagues. Commissioner Myers.
Thank you. I just wanted to speak to this item. That park would not be there if not for Ed Michelow. I know it's very emotional for me because my husband is on the committee. If I look at Jerry,
It's okay.
Ed would be, if he were here, he would be the first one to say it was a team. And it was a team, but it never would have happened without Ed. And that park is gorgeous, and it's something for us to be so incredibly proud of. And I do, when I drive by, I do see people there looking. It's such an enhancement. And that island was really unkept, and now it's gorgeous. It's something that we will be proud of for a long, long time. You'll take your children and your grandchildren there, and it would never have happened if not for Ed Michelow.
Thank you, Commissioner Myers. Other comments or questions? President Spiegelman?
Thank you, Vice President Hecker. To say the least, I share Commissioner Myers' not only commitment but also level of emotion on this subject. I mean, the great irony is, if our dear friend Ed were here with us, he's the last person who wanted anything named after him. Mm-hmm. It is only something that could happen in his absence, which is an absence that everyone in this township, even folks who just started working here or just moved here or just joined the board and never had the pleasure of working with him, his presence is felt every day. It's hard to, this is as important a naming as I will likely ever encounter in my time here. And whether it be whether it be the interpretation of the board's discretion, a change to the policy, a one-time change to exception, this is important. This is an important acknowledgement. It's an important thank you to one of the best friends this township has ever had. Thank you.
Thank you, President Spiegelman. Other comments or questions? Commissioner Schreiber?
So on the broader issue, I would be in favor of keeping the item as it is, but having the leeway that the solicitor just talked about, that we could vote on this particular item, and in the future, if another one comes up that doesn't fit the guidelines, that, we again have a vote on that particular item instead of changing the entire naming policy.
Thank you, Commissioner Schreiber. Yes, I think this policy was designed to give us that flexibility, and we just needed a little bit of a refresher course since it had been a number of years since it had been implemented. Are there comments or questions from our Commissioner Vahey?
If we don't need to amend the policy, then what are we voting on tonight?
What I think, and I was going to ask the same question, is that we would be voting to move this forward at the October board meeting to rename as Mr. Manfredi had indicated at the beginning. We have to change the motion.
Okay. I mean, with greatest respect, I just want to be really careful how we do this, because while I want to give Mr. Michelow all the credit in the world for his work on the park, I do not want to name the memorial for all the township's veterans after one veteran.
No, understood.
It sounds like that's not what's happening here. That was certainly the way it sounded when we discussed this the last time. So
right.
I want to be extraordinarily careful with how this is done. I can think of, and we can discuss it more. That is my number one concern here. I want to give him credit. I'll name, Applethorpe after Mr. Michelow, but I just want to be careful with how it's done with respect to a very important township memorial.
My suggestion, Commissioner Vahey, would be that you consider a motion that would waive this one time, Objective 8, as a general guideline, no facility shall be considered for naming in honor of an elected official or township employee until a minimum of 3 years after the retirement, separation from office, or death. That one provision would be waived in this instance to name it the War Memorial Island, to add Edward R. Michelow Park at War Memorial Island. Be very specific. This one naming at this location, this one time, and this one waiver of that provision of the resolution. If Mr. Clark thinks that that's a proper motion, I don't know, he's probably better suited than I, but.
No, I think that's the way to handle it. If you wish to not follow that particular guideline, there probably should be a motion so that the manager can move forward with doing what needs to do for the sort of processing everything. But I do think that since you are deviating within your discretion from an existing policy, it should be a vote.
I'm truly not concerned with that. We can deal with that. But it's more than just deviating from the policy tonight. It's settling on a name that will be on the agenda for October, which we then cannot amend.
No, you can amend it. Since this is a committee meeting, and it's not a final vote, this would be moved forward to the agenda for the October meeting. At least that's my understanding of how it would move forward. If there are questions about, wanting to possibly alter the name or change it in some way, that can clearly be discussed at the October meeting. And I would suggest that it wouldn't, depending on what you're doing with it, it might not be that great of a deviation that would require it to be pushed out even further. You could probably make not probably, you can make adjustments to it at the October meeting.
Okay.
And again, just to be clear, the reason for my specificity related to the name was the objections that we had heard in the past, where people thought the island was being named, not the park that was constructed within the island.
Right.
So however you choose to name it, just wanted you to understand the rationale behind what I had said.
I get it.
So not to belabor the point, but we started this discussion by indicating that we as a board have the discretion to not follow this guideline. So if we already have that authority, why do we need to make a motion to waive it in this instance? Because we already have the authority to do it.
Well, I think because you are deviating from the policy, you need to make sure that it is a deviation that is being agreed upon by a majority of the board.
But if we simply voted to move this forward to approve the name wouldn't that do the same thing?
In essence, it would, yes.
Okay. I mean, I don't care. I just want to make sure, I don't want to set precedent moving forward. If we have discretion, that every time we choose to exercise that discretion, we have to take a vote to exercise that discretion.
And if you want to move it forward to next month, and then if, by chance, if a board member next month says, well, I don't think we should, the policy says this, we shouldn't be doing that, then at that time, you can just vote to deviate from the
I
policy.
see.
Yep.
I see. Do any of our colleagues on Zoom have comments or questions? Okay. So I think if we want to move this forward to we have to make a motion, either is the way Mr. Manfredi said it, or I think either is fine, but somebody will need to make that motion.
Commissioner Myers, did you want to make a motion, or
I'm sorry, do I want to?
did you want to make a motion, or did you want me to do it?
Well, I would like to make a motion that we consider the resolution amending the policy, and that be placed on the full board agenda next month.
Second.
Is that,
That's
I think,
not.
I don't think,
Is that not specific enough?
I don't think you're planning on amending.
we're not amending the policy. What we're doing
Okay,
is,
That was my-
I'm sorry,
that was my
you're
bad.
right. Well,
I think that the motion would be to, and let me ask, do you want to vote on the name next month?
yes.
Okay, so I think the motion would be to, and I don't know the name, it's to
It's
move
Edmund.
this forward, to approve the naming of what Manager Manfredi had said, and to, you're essentially going to use your discretion to waive the policy regarding the naming of parks. I know that's not a very coherent motion, and I apologize.
Well, I amend my original motion to say exactly what the solicitor just said.
And I amend my second even better.
it has been moved and seconded. All those in favor?
Aye.
Aye.
Aye. Aye.
Is there anyone opposed? Hearing none, the matter will move forward for the October Board of Commissioners meeting as indicated. Thank you. Unfinished business item B is for us to consider advertising ordinance number 2185, amending Chapter 65, burning. And for that, I will turn to Commissioner DePlacido.
Thank you, Commissioner Ecker. I'll keep this brief due to the audio issues, but the consideration before you today is regarding ordinance number 2185, or as some people know it as the hot dog on a stick ordinance, the marshmallow on a stick. That one, that where thousands upon thousands of residents of Abington Township currently own and sometimes operate fire pits, but they are in fact, if you read this ordinance in its detail, it is illegal. And what I'd like to have you all consider here is to come with me and let's make some common sense legislation. I think that through the collaboration with the township manager, all of you, thank you very much for taking my phone call, the solicitor's office, our collaboration with our fire marshal and director of emergency services. I think we put together something that can stand and actually give the ability to residents to have a fire pit, a constructed fire pit, a portable fire pit in their backyard. We did set some guidelines and some rules about it and how to operate one safely and efficiently. And again, it's common sense. Everyone has them. The uptick in the purchasing of all these really hit a peak around COVID. There was that time period where everyone was stuck in their house, but they could go in their backyard and they could convene outside with their families and things like that. Halloween season is coming up, and I assure you, I will smell nicely burning embers throughout the township. And I just want to make sure that all the residents who are in favor of something like this feel safe, one, for having one, and two, feel obligated that they can. I also wanted to mention I polled hundreds upon hundreds of residents, and if I had to put a percentage on it, on an overwhelming percentage, I would say 98.5% were in favor of having something like this. So my ask is that we consider this. I'm not exactly sure how it's written here. Does this mean that if we go ahead and consider advertising this, does this mean it comes up, the actual ordinance comes up for a vote, the revised ordinance?
Correct. The revised ordinance has been presented. If you choose to move forward with this, since it is an ordinance amendment, it'll need to be advertised and then voted on at a future meeting.
Right, what we'd be doing here is
Voting to advertise.
vote, well, can we, or moving it to the full board
Correct.
to vote to advertise?
Which will be October.
That would be October,
Okay.
yes.
All right. So that is my request.
Okay, thank you, Commissioner DePlacido. And with that, I will open it up for comments and questions from my fellow commissioners.
Yeah, I have one.
Okay, go ahead. Is that
Tom, can you hear me?
Yes, Dennis, please go ahead.
Okay. Uh-oh. Oh, okay, I thought I lost it. Now, I've known for years on the books, it's been a law against people using or purchasing fire pits. I'd like to know what our fire chiefs have to say about that, and what the fire marshal has to say about that. And then, does this mean we're going to get rid of that law that we've had on the books for years? I don't know if I lost you or what.
No, we can hear you. We're just working to answer your question,
Okay,
Dennis.
good.
Go ahead, Manager
Thank you.
Manfredi.
To answer the question
So
about,
that was my question.
to answer Commissioner Zappone, the ordinance would amend the current ordinance to provide for this. Mr. McEnany, Director of Fire and Emergency Services, is on here. Both, and I'll just, for the sake, to make sure that everything is clear with communication, Mr. McEnany can weigh in, but both Mr. McEnany and Fire Marshal Rohr did in fact review and comment on the draft ordinance. They also, Tom, can you try speaking? I would rather hear it come from you if you can. If not, then I'll fill in the rest.
I can hear you. Would you like me to take it there? Good evening, Commissioners. Tom McEnany, Director of Fire and Emergency Services here. Yes, as Manager Manfredi had just stated, Mr. Rohr, the Fire Marshal, and I have reviewed the draft ordinance. We did, provide our recommendations and comments. Based on that, obviously we'll enforce whatever recommendation or regulations or ordinance that are passed by the board. And as always, with the fire department, we respond to any call, and we'll respond to any call for service or fight any fire that we're called to. Beyond that, beyond the comments that we provided, I don't know how much more, you're looking for, and I'm not looking to be argumentative. Just that's kind of where we stand.
Okay. What I'm saying, as long as you guys are okay with it, and within that package, is it going to have any distance from a structure, maybe 10 foot away from a structure, a wood structure, whether it be a shed, a residence, a wooden fence? Is there any stipulations in there that say it has to be 10 foot away?
The ordinance amendment as drafted requires that all recreational fires shall be at least 20 feet from any structure, property line, or combustible material.
Okay.
Yep.
Okay. All right, that was my question.
Thank you, Commissioner Zappone. Commissioner Myers? Yes.
Yeah, I have a question. In the previous ordinance, and I'm not sure where it was, but there was something in there about that if the smoke emitted from a fire pit or anything like that, of course, if the smoke was going directly into a neighbor's house, property, whatever, that the fire marshal had the authority, and I'm not sure if to shut it down, I'm not sure exactly what the authority was, but to address that. And will that or something like that remain in the new ordinance? Because I think that's important.
Understood.
Yes.
Turn to the content experts.
What it said, I'm sorry.
No, go ahead, Rich.
What it says is, in determining whether a condition is noxious, hazardous, or excessive, the Abington Township Police Officer, Fire Marshal, or other duly authorized agent of the Board of Commissioners shall utilize 65-3.B, 4A, and B.
If I could just add, if you read through, a lot of the verbiage remained and having to do with the safety of the pits themselves, the distances and things like that. The things that we've added were some modern type things, such as the ability to have a burning fire during a drought season, things like that. That's a no-no, and we had to put other stipulations in there that just contained a small fire, and that's what we're talking about here. We're talking about a small burn, not something larger than 3 feet. We actually have distances and measurements implanted in this as well. We vetted it pretty thoroughly, but we also did incorporate what you were just talking about, Commissioner Myers.
Thank you.
Hey, Tom, I have something else.
Go ahead, Dennis.
Okay. I got to tell you, with the smoke coming from that, okay, people with severe asthma, as myself, people with emphysema, does that pose danger? I know to me because a neighbor of mine has a wood-burning stove, okay, and I got to tell you, when he fires that up, I have a real rough time using my inhaler 2 and 3 times. okay? And since April of this year, okay, I've had 3 of my residents who have breathing problems contact me and complain because their next door neighbor has these fire pits. And, you know, what are we doing about that? People with asthma, people with emphysema. I'm a classic case. The guy across the street from me has that, okay? And when he fires that up, I go through hell. I'm telling you. So one of the residents that complained, he's on oxygen, okay? I went to his house, told him to close all your windows. But you can still, that still permeates through your house. So are we looking in, all these factors going to be included in there? That's just what I need to know.
Thank you, Commissioner Zappone. Again, I'll turn to the content experts.
No, the way the ordinance is, again, as I think what Commissioner DiPlacido said was accurate. This is not a brand new ordinance. Essentially what we're doing is we're inserting a couple of things. We're incorporating the language defining a fire pit and similar types of structures. We're defining a specific size that these fire pits can be. We don't want someone in their backyard having a 30 by 30 fire pit. These are limited to not to exceed 3 foot in diameter and 2 feet in height. So we're keeping them a little bit smaller. We are adding language that if there's a drought or if there's a water emergency or something along those lines, you're not allowed to have the fire pit. So all of the protections that were originally in place through the original ordinance still exist, and you were allowed to have, you know, barbecue fires and things along those lines if they were for cooking. This is just adding for recreational fire pits. So it's not as if like there was a complete prohibition on outdoor burning. We're just adding for fire pits, and all of the other limitations still apply.
So people with medical infirmities like myself are going to be protected. Is that right?
Well,
I'm looking at the health part of it, being an asthmatic myself. So are we going to be protected? Is there some verbiage in there that's going to protect us? You know, that's what I'm worried about, okay? I'm looking at the health aspect of this and people with those medical infirmities.
that language, Commissioner, was not in the original ordinance that dealt with barbecues and recreational fires and things along those lines. So there is not a...
Yeah, but the smell of a barbecue and the smell of somebody burning wood in there is two different smells, okay? So can that be added in there, Mike? If something to that aspect be added in there?
Commissioner Zappone, I certainly would love to talk to you offline. I know we didn't get a chance to talk in depth about it, but, you know, since we're both fire pit owners, maybe we can talk about it, and I'll see, and we'll get Mike in on it as well, okay?
I just want to make sure that, I'm being heard loud and clear. I'm speaking for asthmatics and people with emphysema, those medical infirmities. I want to make sure there's verbiage in there that's going to address that issue. And I don't have a fire pit. I'm just saying, somebody close to me, it's a problem for an asthmatic. It's a problem. So that's all I'm saying. If that can be added in there, something to that effect, that would be great.
Okay, let's talk about that.
Thank you.
Thank you.
Commissioner Myers, and then Commissioner Bowman has his hand up online.
Speaking to Commissioner Zappone, in the original ordinance under Exhibit A, there's a paragraph about excessive smoke and odors, and that smoke and odors are considered excessive if they are perceptible beyond the property line of the source of the fire. Perhaps that language could remain, and that would certainly cover any neighbor with any medical.
I think the concern that any personnel, fire marshal and Mr. Rohr and Mr. McEnany, I'm not speaking for you, but I think the concern that they may have is that they want to be able to identify known substances and not be the arbiter of disputes or concerns with that. If someone has a window open and a fire pit is emanating into someone's living room, that is not an asthmatic, but it bothers them, it becomes a concern of theirs that they would have to get in the middle of a neighbor dispute and not the science or the actual condition. I think what this ordinance is trying to do is to balance all individuals' property rights to the use and enjoyment of their property without inflicting any health, safety, or welfare harm upon their neighbors.
Thank you, Manager Manfredi. Commissioner Bowman?
Just to say that Commissioner Myers covered it perfectly. Our existing ordinance has provision for excessive smoke, and the police can look into it. Because there's no way, Dennis, with all due respect to the asthma that you suffer from, there's no way you can write that into the ordinance. Like, we're just allowing these fire pits because we've all been to parties where they're there. So people are already using them. So we can't have the law
Well, they're not supposed to be using them.
I know, but
So what you're saying is, okay, we're just not going to put in there to protect people with medical infirmities. That's kind of discriminatory. Okay, so I would like to see something worked in there that's going to protect me and my residents that have these conditions. You can't just turn a blind eye to somebody with a medical infirmity. That's discriminatory.
Peggy just mentioned it, the protection that's already built into the law. Fact is, they're out there. People are using them, and they're
Well, they're
filming
not
their
supposed
nose in the law.
to. It's against the law in the
Well,
township.
that's ridiculous, too. That's why we're
Well, they're
changing
not
the law.
supposed to. That's the law. The
Well,
law
we're
has been
changing
on
the
the
law.
books for years.
Well, we're going to change the law.
Well, it better have something in there to protect people with medical infirmities, or that's discrimination.
We just talked about it.
All right, well, I'm just going to make sure that I read that very well, that I'm going to be protected.
Well, the perfect is the enemy of the good.
And there is a section in the current ordinance which is not being removed, which I think Commissioner Myers just referenced, that if it constitutes or creates a nuisance or health risk beyond the boundary of a site on which the condition is located by reason of dissemination of smoke or noxious odors, or endangers surrounding areas by reason of fire or explosion. We're not removing that language. As I said, this amendment is only essentially adding a definition of fire pit, setting a size limitation for fire pits, sending how the distance that it can be from a structure, and then talking about drought and drought prevention and extreme weather conditions. So that other section, Commissioner Zappone, is not being removed. So it's still in there.
Thanks, Mike.
And just to go with what the manager says, I think the problem is it becomes more of an enforcement issue than a writing issue, but it's still in there.
Thanks, Mike.
President Spiegelman.
Thank you, Vice President Hecker. Knowing all the work knowing and following pretty closely all the work that Commissioner DePlacido has put into this, I can tell you I feel confident that this modification of the ordinance still gives our police and fire departments the appropriate discretion to shut things down when they need to be shut down, and also to respond appropriately when it's clear that this is a situation where a neighbor is just trying to get another neighbor into trouble. Certainly, I think as all of us have learned on this job, any of the complaint-driven ordinances, whether they be the burning ordinance, the dog ordinance, the noise ordinance, even parking ordinances, just as there are myriad completely legitimate complaints about violations, there are also a great deal of situations where people will just try to use that and anything else they can in order to get their neighbor busted, get their neighbor in trouble, harass, etc. And I think all of those ordinances do give our enforcement agencies a pretty wide berth to determine the situation, whether this is something legitimate or this is just another way to harass one's neighbor. And I am confident that in this modified version, the burning ordinance will continue to do that. Thank you.
Thank you, President Spiegelman. Are there other comments or questions from members of the committee, either in present or on Zoom? Okay. Did we actually make a motion? I don't recall that we did.
I don't think we did.
Okay. Commissioner DePlacido?
Okay. I'd like to make a motion considering advertising ordinance number 2185, amending.
Right, it's got to go to the full board first.
Moving this forward to the full board.
I'd like to make a motion to move this to the full board.
Second.
The matter has been moved and seconded. All those in favor?
Aye.
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 Any opposed?
I oppose until I'm making sure that I am protected because of my medical infirmity. So I have to oppose it right now.
Okay.
I'm not comfortable.
Duly noted, Commissioner Zappone. Thank you. All right. Item C under unfinished business has been removed from the agenda as indicated earlier. So we now move forward to new business, and we have one item this evening. And this is for us to consider approving the minor land development for the Rydell Park Medical Center patio located at 1515 The Fairway. And for this, we'll turn to Township Engineer, Mr. Hassan. Mr. Hassan, can you hear us?
Sorry, yes, I can hear you. Thank you, Vice President Hecker. This is Lane Development Application 21-06 for Rydell Park Medical Center patio located at 1515 The Fairway. This project appeared in front of the Planning Commission at their meeting back on August 24th, and they received recommendation to move to the Board of Commissioners agenda for further approvals. The project is located within the AO, which is the Apartment Office Zoning District. Under this application, the applicant is proposing to remove approximately 650 square feet of an existing concrete sidewalk and to construct a 2,600 square foot patio and a water feature for a net new impervious area of 2,071 square feet. As part of the construction of the patio and water feature, the applicant is also proposing outdoor seating, a pergola structure over the patio, outdoor grill, kitchen, and island. In addition, the applicant is proposing stormwater management facilities and landscaping. I would like to note that based on the FEMA flood insurance rate map, the firm, which was effective March 2nd, 2016, portions of the parcel are located within the floodplain zone AE. However, based on detailed grading plan dated February 6, 2009, last revised November 5th, 2009, as provided by the applicant's engineer and as part of the medical center land development application, it was determined that based on the elevation shown on the plan, that the proposed site improvements, even though portions of the site are located within the floodplain, are located outside the FEMA floodplain boundaries. As such, there is no concern within the floodplain conservation district requirements within this area. Just want to make sure I note this. So no improvements associated with the site are within any concerned FEMA area. Furthermore, back on April 20th, 2021, the Zoning Hearing Board had granted 6 variances for the site with a couple of conditions, which this land development submission and approval are part of. If I may, I'll just like to go quickly through the waivers that the applicant is requesting.
Certainly.
Initially, it would have been a total of 11 waivers. However, we found that one of the waivers does not apply, and the applicant had withdrew that waiver, which pertains to shade trees. The first waiver is section 146.11A4, which is property identification plans. We support, this is only a partial waiver. We support this partial waiver due to the limited size and scope of this project. Please note that additional information on all this you will find in my August 17th, 2021 letter. And I'm happy to further elaborate on it if the commissioners would like me to. Waiver number 2, which is section 146.11B3, which is from existing features plan. We would support this partial waiver due to the limited size and scope of the project again, contingent that the applicant increase the scale of the aerial image that they have provided to include at least the area within 400 feet dimension beyond the subject property. The third waiver will be section 146.11B7. Again, this is also related to existing features plan. We also support this partial waiver due to the same reason of the limited size and scope of the project. Waiver number 4, section 146.11J, which is recreational facilities plan. We also support this waiver since the recreational facilities are not required within this specific zoning district, apartment office zoning district, nor use a E10, which is the life care facility. So we have no concerns with the board considering this waiver. Waiver number 5, which is the sewer module. We support this waiver. We also coordinated with the Abington Township Sewer Department, and they are also on board with this. Waiver number 6, waiver section 146.11M, 1A, which is the sanitary sewer availability. Again, we coordinated with the sewer department, and there are no concerns. The applicant is proposing to connect to the existing sewer line. Number 7, section 146.11M1B, which related to documentations. The applicant anticipates connection to the existing water line of the proposed sink and kitchen as part of this application. And therefore, we do not see any concerns with it and do support this waiver. Number 8, 146.33C, which is drainage location. There is no concern with this. This relates to the cover over the stormwater pipe. The code requires that a 24-inch cover be provided. Since this pipe that is being requested a waiver from does not exist on the pavement or road, it's just simply an overflow for the stormwater facility, we have no concerns with this waiver. Number 9 also is related to drainage, section 146.33D. We also support this waiver since, the pipe will be essentially serving the overflow pipe from the drainage facility. And lastly, section 142.301B2A, which is stormwater plan content. In addition to the information that the existing features on one of the sheet plans that the applicant is showing, they will include the identification of the steep slope areas, even though it's a very small site, but we have no concerns. This concludes all the waivers. I would like to mention that we are in receipt of comments from the Shade Tree Commission and the EIC back on August 19th, and the applicant has agreed to address all the comments noted in those 2 letters. As such, my recommendation is for the board to consider preliminary final approval for this application. I'm sorry for the long presentation. I'll answer any questions you have for me, and I do believe that there is the engineer of record from Shoemaker on the line if the board would like to ask any additional questions. Thank you.
Thank you, Mr. Hassan. I'll now open it up to comments or questions for members of the Committee of the Whole. Any of my colleagues who are participating by Zoom, comments or questions? Commissioner Weingraff?
Thank you. This is in Ward 7. I just want to say for the record that I'll reserve all questions or comments should this item move forward to the full board for consideration. So thank you.
Thank you, Commissioner Weingraff. All right, hearing no further comments or questions, is there a motion to move this forward for consideration at the October Board of Commissioners meeting?
I'll make that motion.
It's been moved. Seconded? Okay, the matter has been moved and seconded. All those in favor?
Aye.
Aye.
Commissioner Hecker, I just wanted to make sure I understood Commissioner Weingraff. When you mentioned that you're going to reserve your comments, so you're moving it forward without a recommendation. It's being moved forward, but you as the ward commissioner are not making a recommendation as of yet until such time as you see how this plays out. That's correct. Is that what you're, okay.
Thank you, that's helpful clarification. So the matter has been approved to move forward for consideration at the October Board of Commissioners meeting. And with that, we come to the end of our formal agenda, and we are adjourned. Thank you.